to at 6 minutes after 7 o'clock in Trinidad and Tobago. Well, it's 6 minutes after 4 in the afternoon in Pakistan, where Pakistan have won the toss and are batting first against the West Indies in the second one-day international in Multan, where it's almost 45 degrees Celsius. But let's stay back at home, because before the news, we talked about one publication dealing with child abuse and that sort of situation. Now we're going to shift our focus to industrial and labor matters, because the president of the Industrial Court, Deborah Thomas Felix, is launching her second book on labor law. Her first book was launched almost a year ago. Today we'll be joined by her to discuss her latest work that's entitled Labor Law and Good Industrial Relations, which deals with, among other things, verbal and written warnings, suspension from work, summary dismissal, the right to be heard, unilateral alteration of terms and conditions of employment. The book also explores maternity protection at work and contains a glossary of various legislation on maternity protection from regions elsewhere in the world. Ms. Thomas Felix, very good morning to you. Thanks for joining us.
Thanks for having me.
You're more than welcome. Is the publication already available?
Yes, it is available. It's available online at a Spotify shop, which is, you have to go to www.trendsinlaborlaw.com and you place your order for the books there.
And for the diner stores still plodding around like myself, who might be looking for a publication in an actual store where you walk in and actually pick up a copy in your hand, is it available in any bookstores?
No, it's not available at bookstores.
And is there an intention to make it available, or are you satisfied just to have the online platform?
The online platform is fine in the sense that the book, while available to the general public, the specialists, students, lawyers, etc., they normally would access the book. They would send an email or WhatsApp. I have to get the WhatsApp number, but they will send a WhatsApp and an email if they cannot go online. There's some people who cannot go online. There's a number that they just call and place their orders on it.
Okay, so again, is it really a specialist publication then? Who do you think it's best designed? When you were compiling it, as with your first publication, who really benefits from the information in this publication now?
This publication, apart from the industrial relations specialists, it would be very useful for HR persons, because and also small business owners who may not be able to afford to have consultants in industrial relations. Because the issue of whether I should give a warning or whether I should not give a warning, whether I should suspend someone or should not suspend, what form it should take, what are the processes, those are issues which not only engage IR consultants and IR specialists, but human resource persons in organizations will find themselves having to deal with these things.
And why did you feel the need to put it all in the form of a book? Based on your experience, of course, the president of the Industrial Court, why did you feel it necessary to put it all together in a book form?
Well, there's a knowledge gap. A number of matters which reach to the Industrial Court, in my mind, could be settled in the workplace amicably. And there's a knowledge gap because a lot of people do not know what is the process, what should be done, what is the law. And some of them rely on the bush lawyers, as I will call them, to guide them as to what the process is. And in my mind, if it is written in some shape or form, together with whatever other writings there are, it will be able to assist persons to know what is the right thing to do at the workplace. And of course, it might give me a little less work.
You want less work?
Yes, I do.
Well, maybe I should give you a waka so to cut down the bush so we can see who the bush lawyers are in that sense. But in relation to that, I mean, people like myself, simpletons like myself, are easily intimidated by law and legalese and so on. But when we talk about understanding all of the rules under industrial law and so on, is it something that For example, this publication that you've put out, is it something that can be easily understood by someone without a law degree?
The book is written in very simple language, both books actually. I took the decision to write it in simple language so that anyone can pick it up and follow it. And from the reports that I have received and the reviews that I have received from the first one of the first review is how simple the style of writing is. So you do not have to be a lawyer. And I think that is one of the things that occupied my mind. So I wouldn't call you a simpleton. As a matter of fact, I think you're very, very well versed and learned. But anyone who is not an expert in the area can pick up the book and say, do I give a warning, a verbal warning? Do I have to? If I should dismiss someone, should I just call them in and dismiss them, or is there a procedure? And I've written it in as simple as language as possible. And then I have attached the cases, which will go further to explain the language that I have put. So by the end of the cases and what I have read, what I've written, you will be able to have a sense in a simple way as to your next step. You will then decide what you will do, whether you proceed with that sort of action, but it prevents you, not prevents, but it helps you in such a way that you may not need to hire a consultant or go to a trade union. Or if you go to the trade union, it might be because you are of the view that your rights might have been infringed.
Well, as you're talking about that, if I could squeeze in a request, I'm looking for some free advice here, Miss President of the Industrial Court. I bounced up somebody on Rail Street in Samoa yesterday who was asking me precisely that thing. They feel they were wrongfully dismissed and they wanted to know if they have to go to a union for representation or can they advance their cause personally without having to go through the expense of hiring a lawyer. I mean, it might be inappropriate of me to ask you that question. I don't know, but is that possible?
That is an important question because that is a question that a number of persons grapple with. The industrial court does not recognize individuals. And what I mean by that, we only treat with unions and companies, except in matters of occupational safety and health. However, in some companies, they are what we call RMUs, recognized majority unions. So if you are in an organization that has an RMU, you will speak to your shop steward or your union official. But many organizations don't have RMUs and there's no union there. So what you will do is that you will go to a union, join the union, and the union will then take up the matter with the organizations. And if that fails, they will take it to the Ministry of Labor. The Ministry of Labor, there's a process there where there's conciliation, etc. And if that process fails, then the Ministry of Labor sends something called a certificate of unresolved dispute, meaning that it has broken down completely. And then they send it to the industrial court for us to attend to.
And so, just so I can understand that clearly, so can an individual approach the Ministry of Labor directly without that union representation?
No, they have to go to a union.
Okay.
Now, if it is a matter of occupational safety and health, you can come directly to the court. You do not need to have a union. But unions represent persons in matters of OSH.
Okay, but getting back to the publication, this second publication, Labor Law and Good Industrial Relations, how much of this information and in fact advice or recommendations in this publication or even the first publication, would you describe as just basic common sense, notwithstanding all the fancy legal language? How much of it would you describe as basic common sense, understanding the specific parameters of the laws of Trinidad and Tobago?
There's a famous judge from England called Sir John Donaldson who said that the industrial court is a court, but it is more than a court. It is a court of common sense. So the commonsensical approach is what is expected. And if you look at our legislation, the Industrial Relations Act, it removes the fetters of the law of evidence so that people can come, relate their stories, give their common sense account, and then we treat with it. So a lot of it is common sense, but the whole notion of industrial relations is really predicated on transparency, fairness, and equity. So if you understand basic rules of fairness, basic rules of natural justice, and transparency, then that is the route to common sense to solve the problems.
But you've just touched on an issue there, because somebody's idea, my idea of fairness might be different from your idea of fairness. My idea of the right process might be different from your idea of the right process. How much of this actually has to do with people not wanting to be seen to be giving ground to the other? They don't want to be seen to be losing, because we have such an adversarial environment, whether we're talking about the general legal system or the industrial court system. So much of it appears, again from a layman's point of view, to be seen that I don't want to be seen as losing out to the next side.
Well, there are two things. One part of the industrial court treats with conciliation. We offer conciliation to parties, and if you go to conciliation, it's usually a win-win situation. Parties work out with the conciliator judge the terms that they think suits them. So when you leave there, it is not somebody has lost. If it goes into open court, obviously that's the adversarial part. But we encourage at the industrial court bilateral talks even before we get to the conciliation stage. So we will, I usually do case management apart from open court hearing. And I will ask parties, do they wish to speak? Because we try to encourage that conciliatory approach before you get to the adversarial approach. Now, if you look at if you were to get to the publication, we have a body of law and jurisprudence which has developed since 1965, since the days when our president of the court was Sir Isaac Hayatali. And those cases, which we call jurisprudence, guide persons as to what are the right standards and what are the right rules for the workplace. Then, of course, we have the international labor standards, and I think you know that I am a member of the committee of experts on that labor standards. And those standards guide not only persons in Trinidad and Tobago, but throughout the world as to what should be the right standards and the right approach. So after a while, with our body of jurisprudence, which has developed since we've become an independent state, by now, we should be able to know this is what is required. This is what is not acceptable. And so that is what I've tried to reduce as much as I can in a book of about 500 and something pages, but as much as I can.
Well, that sounds like a legal professional's publication, 500 and something pages. And that's why I always ask the question, as you said, you use very simple language in the first one, and that's the sort of response that you've gotten. And therefore, are you satisfied, based on the responses that you've gotten, with the second publication as well, that people understand and get the message that you're bringing across with your intention, what sort of reactions, in other words, I'm asking, have you gotten to the second publication so far?
All right, so at the launch I had, Fazeer Mohammed, who is one of the managers at Angostura, spoke at that launch. And he said that the organization purchased books, and they gave the books not only to their management, but to their union and their union members. And what they have done is that they hold sessions to discuss the principles in the book. And he has said that they have found that there is a reduction of this adversarial approach and a better understanding of what the requirements are and what the standards are. So to answer your question, the feedback generally is that people find it to be very useful and user-friendly.
Do you use the word ought in your publication?
No.
I'm glad to hear that. I'm glad to hear that, Ms. Thomas Felix. This ought, I think you'll need to remove that because it's either is or it isn't. This ought thing, it not working. I know it's a word, but in some cultures the word ought don't exist or the context don't exist because something either is or isn't. But anyway, it's I suppose an irrelevant talking point. But before time runs out on us, Ms. Thomas Felix, just remind everybody once again about this second publication, Labor Law and Good Industrial Relations, how they can access it, and indeed who you're gearing it towards as your final summation, please.
Well, I'm hoping that everyone will take a read, especially library students of industrial relations practitioners, but more importantly, HR practitioners. And you can get it at www.trendsinlaborlaw.com, one word. Labor is spelled L-A-B-O-U-R, not the American way. So trendsinlaborlaw.com. And if you go on that website, you will get all the email addresses and the telephone numbers so that you will know how to go about getting the book. I have to give some consideration as to whether I'm going to put it into a bookshop. I just think I might take up a lot of my time. But
Indeed.
I would give some consideration to that.
Well, maybe you could pass over to the industrial relations people and get rid of the bush lawyers, so you might have more time available to get the book on the shelves. Thank you very much indeed for taking the time,
Thank you
Mr.
so much for having me. I appreciate it.
You're more than welcome.